Hello students, I am JV'n Nehal Mittal and your topic for today is negligence. So, according to Winfield and Jolvik, negligence is the breach of a legal duty of care by the plaintiff, which results in undesired damage to the plaintiff. In Blyth versus Birmingham Water Works Company, negligence was defined as the omission to do something which a reasonable man would do or doing something which a prudent or reasonable man would not do. So it can be characterized in three forms. One is non-feasance, second is misfeasance, and third is malfeasance. So when you talk about non-feasance, it means the act of failure to do something which a person should have done. For example, if there is a failure to carry out the repairs of an old building when it should have been done. Now, misfeasance means the act of not doing an action properly when it should have been done properly. For example, if doing the repairs of an old building but doing so by using very poor quality materials, creating a major probability of a collapse which injures people. Then malfeasance. So malfeasance means the act of doing something which should have been done in the first place itself. Example for this is that one is using products that are not allowed and combustible to carry out the repairs of an old building, therefore converting the building into a fire trap, leading to an accident. Illustration for these are: suppose Z, an owner of a big dog, requests his friend X to take care of the dog while he is away. So X leaves the dog unattended, who attacks a passerby, badly injuring him. So here it will be said that the act occurred due to the negligence of X. So in the general sense, the extent of liability in tort is determined by the number of damages a party has incurred. Consequently, in criminal law, the extent of liability is determined by the amount and degree of negligence. So, essentials of negligence. To commit the tort of negligence, there are primarily six main essentials. The first essential is duty of care. In this, it is the person is made liable on the condition of care, and it is an essential condition. This means that every person who owes a duty of care is to another person while performing an act. Although this duty exists in all acts, but in negligence, the duty is legal in nature and cannot be illegal or unlawful, and also it cannot be moral, ethical, or religious nature. The next duty is the duty must be towards the plaintiff. So, this duty that arises when the law recognizes a relationship between the defendant and the plaintiff requires the defendant to act in certain manner towards the plaintiff, and it is not sufficient that the defendant owed a duty of care towards the plaintiff, but it must also be established, which is usually determined by the judge. The next essential is breach of duty of care. So, it is not enough for a plaintiff to prove that the defendant owed him a duty of care, but he must also establish that the defendant breached this duty of care that was towards the plaintiff. So, a defendant breaches such a duty by failing to exercise reasonable care in fulfilling the duty. In other words, the breach of a duty of care means that the person who has an existing duty of care should act wisely and should not omit or commit any act which he has to do or not to do, as said in the case of Blyth versus Birmingham Waterworks. In simple terms, it means non observance of a standard of care. The next is actual cause or cause in fact. So, in this scenario, the plaintiff who is suing the defendant for negligence has the liability to prove is that the defendant violation of duty was the actual cause for the damage that is incurred by him by the plaintiff. So this is often called as but for causation, which means that but for the defendant's action, the plaintiff would not have incurred the damages. For example, when a bus strikes a car, the bus driver's actions are the actual cause of the accident. Proximate cause. So, proximate cause means the legal cause or the cause that the law recognizes as the primary cause for the injury. It may not be the first event that set in motion in sequence of the events that led to an injury, and it may not be the very last event before the injury occurs. Instead, it is an action that produced forcible consequences without any intervention from anyone else. So a defendant is in negligence case is only responsible for those damages that the defendant could have foreseen through his actions. The next essential is consequential harm to the plaintiff. So, proving that the defendant failed to exercise reasonable care will not be enough, and they should also prove that the failure of the defendant to exercise reasonable care resulted in the damages to the plaintiff to whom the defendant owed a duty of care. So, the harm may fall into the following classes: first, bodily harm; second, harm to the reputation; third, harm to the property; fourth, financial loss; last is mental harm. When such damage is proved, the defendant is bound to compensate the plaintiff for the damages occurred. Res ipsa loquitur. So, this Latin phrase means the thing speaks for itself. So, this is considered to be a type of circumstantial evidence which permits the court to determine that the negligence of the defendant led to an unusual event that subsequently caused injury to the plaintiff. Although generally the duty to prove that the defendant acted negligently lies upon the plaintiff, but through this phrase, res ipsa loquitur, if the plaintiff presents certain circumstantial facts, it becomes the burden of the defendant to prove that he was not negligent. Thus, the following are the three essential requirements for the application of the maxim. The first is the thing causing the damage must be under the control of the defendant or his servants. Second, the accident must be such as would not have happened in the ordinary course of the things without negligence. And last, there must be no evidence of the actual cause of the accident. So, this doctrine arose out of the case of Bryan versus Bodley. So the plaintiff was walking by a warehouse on the road and suffered injuries from a failing barrel of flour which rolled out of a window from the second floor. At the trial, the plaintiff attorney argued that the facts spoke for themselves and demonstrated the warehouse negligence since no other explanation could account for the cause of the plaintiff's injury. So now let's see the defenses that are available for the suit for negligence. The first defense available is contributory negligence by the plaintiff. So if there is a contributory negligence, that means when the immediate cause of the damage is the negligence of the plaintiff himself, the plaintiff cannot sue the defendant for the damages and the defendant can use it as a defense. So this is because the plaintiff in such a case is considered to be in the author of his own wrong. It is based on the maxim voluntary non fit injuriae, and the plaintiff is not entitled to recover from the defendant if it is proved first that the plaintiff, by the exercise of ordinary care, could have avoided the consequences of the defendant's negligence. Second, the defendant could not have avoided the consequence of the plaintiff's negligence by an exercise of ordinary care. Third, there has been as much want of reasonable care on the plaintiff's part as on the defendant's part, and the former cannot sue the latter for the same. Now, the next defense is act of God. So, an act of God is a direct, violent, and sudden act of nature which, by any amount of human foresight, could not have been foreseen, and if foreseen, could not by any amount of human care and skill have been resisted. So, thus, such acts which are caused by the basic forces of nature come under this kind of category. For example, storm, tempest, extraordinary high tide, extraordinary rainfall, etc. So, if the cause of injury or death of a person is due to the happening of a natural disaster, then the defendant will not be liable for the same provided he proves that the same in the court. So, this particular defense was discussed in Nichols versus Marshland, in which the defendant had a series of artificial lakes on his land, and there had been no negligence on part of the defendant in the construction and maintenance of these artificial lakes. Due to unpredictable heavy rain, some of the reservoirs burst and swept away four country bridges. It was held by the court that defendant could not be said to be liable since the water escaped by the act of God. Now, the next defense is inevitable accident. So, an inevitable accident can also be called as a defense of negligence, and this refers to an accident that had no chance of being prevented by the exercise of ordinary care, caution, and skill. This means physically unavoidable accident. In the case Brown versus Kendall, the plaintiffs and the defendant dogs were fighting and their owners attempted to separate them. In an effort to do so, defendant beat the dogs with a stick and accidentally injured the plaintiff, severely injuring him in the eye. The plaintiff brought suit against the defendant for assault and battery, and it was held that the injury of the plaintiff was a result of an inevitable accident.